Yes, we are live. So go ahead, sir.
Yes. Good evening to all of you. Yesterday we were discussing about different types of drafting as far as the conveyancing is concerned. Now we go to the pleading aspect of it because I don't want to go to the Companies Act because Companies Act there were two documents called the Memorandum of Association and Articles of Association. Nothing much to be said about it because no company comes to you to draft a memorandum and articles. Normally, they go to a chartered accountant to draft it according to the Companies Act. So now we go into the pleadings part of it as far as various types of suits are concerned. Here, I have completed the conveyancing actually. We come to the practical aspect of how a plaint has to be drafted. As far as a money suit is concerned, I think most of you are advocates. You know the procedure. But the essential ingredients of a plaint is that the first is the plaint. All plaints are filed under Order 7, Rule 1, read with Section 26 of the Civil Procedure Code. Then the name of the court, OS number of whichever year it is. Then between name of the plaintiff and name of the defendant, name of the plaintiffs or name of the defendants, and then you say what is the suit for recovery of money, and then underline it, and then you say the plaintiffs above name beg to state as follows. First paragraph, you concentrate on name, address, and description of the plaintiffs. Next one is name, address, and description of the defendants. Third one is the address for service of all processes and notices on the plaintiffs is that of their counsel so and so, with your email number and cell number and your address. Then next paragraph is the address for service of all summons and notices on the defendant or defendants as the case may be, is the same as given above in the cause title. Then what do you mean by cause title? Cause title means the descriptive description of the parties which you give in the give above. That is what is called cause title. Then next paragraph is brief facts of the case. A. That the plaintiff and the defendant are acquainted, plaintiffs and the defendants are acquainted with each other. That the defendants approach the plaintiffs for a hand loan of 50 lakhs to meet their business requirements, and the plaintiff agreed to advance the said amount, and the defendants executed a promissory note and receipt for the said sum on so and so date. The promissory note and receipt are filed and marked as documents 1 and 2. Then the B, we say that the that in spite of several demands and requests, the defendants have not paid the suit amount to the plaintiffs, and therefore the plaintiff, through their legal notice dated so and so, called upon the defendants to pay the suit amount. The defendants received the notice but did not send any reply. The office copy of the legal notice, along with the acknowledgements, are filed and marked as documents so and so to so and so. Then next paragraph you concentrate on what is called the plaintiffs rely on the following documents in support of their claim. One, the original promissory note and receipt dated so and so, executed by the defendants in favor of the plaintiffs. Then second one is the office copy of the legal notice dated so and so, uh, uh, dated so and so, issued by the plaintiff's advocate to the defendants. Then next one is postal acknowledgements. They are the crux of the matter. They are called suit documents. Then next paragraph you write is cause of action for the suit arose on whatever date the promissory note is executed, and then you say and also on so and so date when the defendants were called upon by the plaintiff's legal notice to pay the suit amount, and the defendants received the notice but did not send any reply, hence the suit. The next paragraph is this honorable court has got jurisdiction to try this suit as the parties reside and work for gain at Hyderabad within the jurisdiction of this court. Next paragraph is the suit is valued for the purposes of court fee and jurisdiction at 50 lakhs or whatever interest you are going to charge, and a court fee of rupees dash is paid under Section 20, read with Schedule 1, Article 1B and C, TGCS SVCA Act. And next paragraph is you say that the plaintiffs hereby declare that they have not filed any suit in respect of the same claim before any court nor any suit is pending. Then the last paragraph is the plaintiffs therefore pray for a judgment and decree against the defendants jointly and severally as follows. A. For recovery of rupees so and so towards the principal amount lent to the defendants by way of the promissory note and the receipts. Second one is interest on rupees so and so 50 lakhs at 24% per annum from date of the promissory note till the date of suit. Then next one is future interest at 24% from date of suit from date of suit till date of decree and date of realization. And last one is you say for cost of the suit. And last one, most of the advocates write for such other relief or reliefs as this honorable court deems fit and proper. Then the party signs the parties, whoever are the parties, they sign, and the council also signs on the other side as having accepted the brief. Then the parties say, "I, we, the plaintiffs above named, declare that the facts stated in para so and so to so and so, that is before the cause of action paragraph, are true to the best of our knowledge, and the contents in para so and so, right from cause of action to the prayer, are true to the best of our information, which we believe to be true after the contents were read over and explained to us in Telugu or English, whatever it may be. Then the parties are verified at Hyderabad on this the day of so and so. Then down, all the plaintiffs sign. Then whatever documents you are relying upon, you mention it as list of documents 1, 2, 3, and 4. Then the party also signs, and the Hyderabad, that side you write Hyderabad and the date. And then you prepare the docket also. That's how a plaint is drafted in a money suit. Then one more paragraph, if you want to write, you can write saying that the suit is within time and within the period of limitation as it is filed within the period of 3 years. Then, if there is any acknowledgement of the debt and the defendants pay a part of the amount which is endorsed on the reverse of it, you also mention it saying that the defendants admitted their liability and paid a sum of rupees so and so towards the part payment which is endorsed on the reverse of the promissory note and receipt, and hence the suit is protected under section 17 and 18 of the Limitation Act. So this is how a ordinary money suit is prepared. Then you take a classic case. Suppose in addition to the promissory note as well as the receipt, the loan is also secured by a guarantee furnished by other parties. The guarantors also will have to be made parties and say that the loan granted to the different loan, the hand loan given to the defendants was also secured by the guarantee furnished by defendants 5, 6, and 7, who executed a guarantee agreement in favor of the plaintiffs. And since the defendants 7, 8, and 9 have executed the guarantee agreement in favor of the plaintiffs, they are also jointly and severally liable to pay the suit amount to the plaintiffs. The original guarantee agreement is filed herewith and marked so and so. So this is how an ordinary money suit is drafted. Suppose let us visualize a situation. Suppose the bank files a suit. I'm not talking about a mortgage suit, sir. For the bank files an ordinary suit for money, and let us say cash facility and the credit facilities are given. What are the documents which the bank files, sir? The bank files the original promissory note, receipt, then also the agreement for cash credit, and then signed by the party. And if any guarantee is given, the guarantee signed by the guarantor, and all these documents, and along with the extract of the account is filed along with the suit. They are all called what is called suit documents. And please remember, whenever a suit is filed in a civil court, all the original documents called suit documents have to be filed along with the plaint. You cannot file it later. Then the bank also takes, I told you in the previous lecture also, the bank takes what is called AOD, COB, and revival letter. Then in the limitation paragraph, you say the suit is also within time as the defendants acknowledged and admitted their liability and executed a COB, that is called confirmation of balances, acknowledgement of debt, as well as revival letters, which are filed along with the suit. That is, if in case the bank files a suit. Then please remember in the cause title, when you describe the plaintiff, as far as, let us take an example, suppose the State Bank of India files a suit. Please remember there is one regulation called State Bank of India General Regulations, Gazette 1, date in 1955. There, every branch manager of a bank is authorized to sign under Rule 76 and 77 of the regulations. Every branch manager or chief manager is entitled to sign and verify the plaint. In the regulations itself, power is given to them. Then earlier in 1956, we had the State Bank of India Subsidiary Banks Act of 1956, so like State Bank of Hyderabad, State Bank of Travancore, and so on and so forth, which also ultimately they merged with the State Bank of India. But under the regulations itself, the branch manager has got the power to sign and verify the pleadings. Right? Then, if you take the case of a non-national, I mean, other nationalized banks like Indian Overseas Bank, Indian Bank, Syndicate Bank, so on and so forth, Union Bank of India, and all, there are no regulations there. What happens is please remember, not only the branch manager, every officer of the bank is given a power of attorney by the bank that to represent the bank to file and present pleadings on behalf of the bank, and the branch manager need to file only the Xerox copy duly attested before the court, because he is not supposed to part with the original GPA, because original GPA is something like an appointment letter for an officer of uh, ex, uh, uh, other than State Bank of India. And once it is filed, he signs and also verifies the plaint for and on behalf of the plaint of the bank, and then puts his seal also on that, and it is filed accordingly. This is how the money suit is filed when a bank files it uh, on behalf of the bank. The officer of the bank is authorized to sign because of the GPA given in his favor, and it's also preferable to file a petition under Order Rule 32 and 33 when the bank is represented by a GPA holder to seek permission of the court to prosecute the suit for and on behalf of the bank, and the the copy of the GPA is filed along with the plaint. Please bear one thing in mind: the bank need not file the original ledger into the court. They can only file what is called a certified extract, duly signed by two officers of the bank and also signed by them and with a rubber stamp, and that is sufficient under Section 4 of the Bankers Books Evidence Act. But otherwise, if suppose a normal person files a suit, then he has to file the account statement, or what is called in Marwadis, they call it as Paddu. Paddu is a khata which is kept and maintained by the Marwadis as far as credit transactions are concerned. There the party signs. Then you file an extract of it. Suppose normally Marwadi language is very difficult to decipher. Then in that case you file an extract, get it compared with the in the section, and also encircle it by saying that the extract that is filed is a replica of the original, which is kept and maintained by the Marwadi as far as his regular course of business is concerned. But when the question of trial comes, the original Kata book has to be filed into the court. The only exemption that is given is the bankers are exempted from filing the original ledger into the court. Are you able to understand, please? Because Section 4 of the Bankers Books Evidence Act says an extract duly certified by two officers of the bank and duly sealed can be filed, and that is prima facie proof of the account kept and maintained by the bank in the regular course of business. And whatever documents is the foundation of the claim has to be filed in original. They cannot be filed later. But here, a distinction has to be made between a suit document and an evidentiary document. Please remember, sometimes there are communications between the plaintiffs and the defendants in the form of letters, in the form of correspondence, or in the form of something where the defendants admit their liability or acknowledge their liability. And please remember, those are documents which you need not file. You can file it later also, or when the party comes into the witness box in cross examination, you can definitely confront those documents and get it marked. And that is the privilege of a cross examiner, not to file evidentiary documents, but evidentiary documents can be confronted at the time of cross examination. That is a classic rule of Evidence Act. So this is as far as the money suit is concerned. Are you able to follow the pleadings of a money suit, please? And along with the suit, you are supposed to file what is called the Wakalatnama. Wakalatnama means you act as the agent of the party. You have to represent the party. You have to argue on behalf of the party. You have to conduct the trial in the case. You are the person authorized to prepare the pleadings and also file evidence, prepare the affidavits and petitions which are required from time to time. And you act as the agent as far as the bank is concerned or the private party is concerned. So that is why it is said in order 3 and order 4, when the party appears, he can appear either by himself or through his agent or through an advocate duly authorized through a wakalatnama which is filed into the court that gives the power to an advocate to represent the party. Then along with that, you are supposed to file what is called the BATA or process as you call it, Form 61. And Form 61 has to be duly filled up, the regular columns, and then you have to enclose what is called the forms called for the summons for settlement of issues which are under Order 5 Civil Procedure Code. And then for each party, you must uh, furnish 3 forms because whenever the first time you file the suit, the summons have to go through court and by registered post. And along with that, the cover and the acknowledgement and the necessary postal stamps have to be affixed. And the plaint also has to be accompanied by copies of the plaint, which has to be served on the defendants as per the civil rules of practice. And along with that, you have to file what is called form number 51, which is called list of documents. I think perhaps for most of you know printed forms are available nowadays. So in that you say 1, 2, 3, 4, 5, 6, and whatever documents you file, and the advocate signs on behalf of the party, and copies of the documents or what is called material papers have to be served on the other side. Extra copies have to be provided, and even for that, what you call it as, it is mandatory that the parties are entitled to a copy of the documents which are filed into the court. And please remember the consequences of not furnishing the copies. You have got the civil rules of practice, which deals with Rule 125, 126. And kindly note this, please. Please remember, because someone says, sir, please give us time to note down. Rule 125, Rule 126, Rule 127 of the Civil Rules of Practice, which says that you can file a memo into the court if you are the defendant. Sir, I have not received the copy of the plaint. I have not received the copy of the petitions. I have not received the copies of the documents. Kindly direct the opposite side to furnish copies. Please remember, you need not beg the other side to give a copy. It is available to you as a matter of right. When you file a memo under 125 Civil Rules of Practice, then the court directs the other side to furnish copies under Rule 126. And suppose the order that is passed or the direction that is passed by the court under Rule 126 pursuant to Rule 125 memo being filed by the defendants who have not received the copy, the court under 127 can reject the documents and even in certain circumstances can reject your plaint also. Again, I'm repeating Rule 125, Rule 126, and Rule 127. You need not beg the other side for a copy. It is available to you as a matter of right, because when you prepare your reply, when you prepare your written statement, you must know what is written in the plaint, what is asked as against you, what is the grievance of the plaintiff, what is the point you have to meet, and how you have to meet. That you can try to decipher and prepare your written statement only after looking into it. Please don't beg the other side for a copy. You are entitled as a matter of right. Only thing is, try to use your brains, file a memo under Rule 125, Civil Rules of Practice, asking the court to give directions to the other side to furnish copies. And under 126, the court passes the directions. Under 127, if the copies are not furnished in spite of several adjournments, then in that case, your documents will not be accepted, and in some cases, your plaint also can be rejected. Why I'm telling you all these things is, where you have got an institution, where you have got an office called the Nazarat, or what is called, from where the processes are handed over to the process server by the Nazar for the purpose of service of summons on the opposite side. And please remember, if you I think most of you are attending course, you find the process servers only going about with a small black bag. In that bag, only the summons will be kept, And what about the copies? Without copies, your case will not be numbered, your suit will not be numbered. But what they do is, all these copies, they throw it in the dustbin and you will not get it. And in spite of inspecting the file, you don't get the copy. A copy is not a charity. Every defendant is entitled to get a copy and the copy of the material papers also. That's why I was suggested to the Law Commission, like criminal cases, when the accused appears before the court for the first time and the copies are already furnished by the police, the court directs the copies to be furnished to the accused on the first date of hearing itself. Please remember the principle of Ari Altram Partham. That means no man can be condemned unheard. He must be given a hearing. He must be given ample opportunity. There must be transparency in the judicial proceedings. It should not be one-sided. It shall be to both sides, and both sides should be given an opportunity of laying their case and also laying their defense. Please bear this in mind, please, because don't beg the other side for a copy. 125 rule is there. You file a memo, simple. 126, the court passes the direction. 127 is, even after the direction, if the copies are not furnished, then the court dismisses the suit or rejects the documents also. But here, what happens is, it's not the mistake of the plaintiff's advocate, sir. Please remember, without furnishing copy, without enclosing the copies, the suit will not be numbered. But what they do is, because of the mischief committed with the Nazaret, what happens is, you are asked to make out copies again and furnish it to the other side. Please remember, if you are appearing for an institution, the bank also pays you only 2 times for the document xerox. Second time, you will have to pay from your pocket. I think I've suggested to the Bar Council also, even in civil matters, the party should be furnished copies when they appear in the court so that this mischief will not be committed. Are you able to understand, please? This is how a money suit is drafted. Please remember, go for short paragraphs. Go for paragraphs which is easily understandable. And if you have got 6 documents, go for 6 paragraphs, so that even if you are not there being a senior, your junior also can conduct the cases. So this is how a money suit is filed, either for the bank or for a private party. Then we go to the mortgage suit. How a mortgage suit is drafted. I think one lady by name Jyotirmai asked me, I think she contacted my admin who referred the matter to me as to whether in a mortgage suit you have to mention whether order section 26 read with order 7 rule 1 CPC. No, you have to mention plaint filed under order 34 civil procedure code for enforcement of mortgage. Why? Because as far as mortgage is concerned, is a special type of suit where some special particulars have to be mentioned. Then, first of all, begging the question, sir, again I repeat, what is the definition of the word mortgage? Mortgage is supposed to be, in our agency area, it is called Tanaka. And as far as our cities and all are concerned, because Hyderabad is half Urdu and half Telugu, we use the word girvi, where interest in specific immobile property is created for the purpose of securing a loan paid or promised by the mortgagor in favor of the mortgagee. The transaction is called a mortgage, and the person who offers the property as security is called the mortgagor, and the person to whom the property is offered as security is called the mortgagee, and the transaction is called a mortgage, right? Then, depending on the kind of mortgage which you have got, you have to draft the plaint. First is the name of the court, then the number of the suit, then between whomsoever is the plaintiff and whomsoever is the defendant. Then you say suit filed under Order 34, Civil Procedure Code. Then first, all the particulars are saved, address or service address. Next para is brief facts of the case. Here you say that on so and so date, the defendant approached the plaintiff for loan facilities and the cash credit Mandi type for up to a limit of 50 lakhs and executed an agreement for cash credit Mandi type in favor of the plaintiff bank. The original agreement is filed herewith and marked so and so. The defendant also executed a promissory note and receipt in proof of payment and dated so and so, and the same is also filed and marked as document number 3. Then coming to the next paragraph, that the loan facilities granted to the defendants was secured by a collateral security or by the defendant depositing the original title deeds of his property bearing number so and so, and executed the proper documents for the said purpose. The documents are filed herewith and marked so and so. Next para. The loan facilities granted to the defendant number one was also further secured by the personal guarantee of defendants 2 and 3 who executed a guarantee agreement dated so and so in favor of the bank, and the same is filed herewith and marked so and so. Then next para. In spite of several demands and requests, the defendants have not paid the amount, and therefore the plaintiffs, through their legal notice dated so and so, called upon the defendants to pay the suit amount. The defendants received the notice but did not send any reply, and the office copy of the legal notice along with the postal acknowledgements are filed and marked so and so. Next para will be, as per the extract of account duly certified under the Bankers Books Evidence Act, a sum of rupees so and so is payable towards the suit claim. 1. Amount due under the loan so and so. Then interest from so and so to so and so, so and so. Then next one is, third one is future interest at 24% per annum. Then fourth is any amount paid nil. Then a total amount due so and so. Then we come to the next paragraph saying that the defendants deposited the original documents pertaining to their property bearing number so and so, situated at so and so, by way of collateral security and equitable mortgage to secure the loan facilities, and the original documents are deposited at the bank, are filed and marked so and so. Next is, in the same paragraph, we say the defendants also acknowledged their liability and executed three documents. One is called AOD, that is acknowledgement of debt, COB, that is confirmation of balances, and also revival letters, which are filed and marked so and so. Are you able to follow, please? Next para will be that the cause of fact, that the particulars of the mortgage. 1. Please remember, the only difference between an ordinary money suit and a mortgage suit is, in a mortgage suit, you will have to give the particulars of the mortgage as required under Order 34 CPC. What are those particulars, sir? 1. Name of the mortgager with his address. Name of the mortgagee with address. Third one is the amount due under the loan, so and so. Interest charge, so and so, at 24% from so and so to so and so, equal to so and so. Fourth is the less amount paid, nil. Then after that, documents deposited. The documents given by the defendants. One is agreement of cash credit dated so and so, executed by the defendant in favor of the plaintiff, dated so and so. Number 2, guarantee agreement dated so and so, executed by the defendant so and so to so and so, in favor of the bank. Third one is the original promissory note dated so and so, executed by the defendant number 1, along with the demand, they call it demand promissory note, in favor of the plaintiff, dated so and so. Next one is office copy of the legal notice dated so and so from the plaintiffs to the defendant. Next one is the COB executed by the defendants in favor of the plaintiff, dated so and so. Next one is AOD executed by the defendants in favor of the plaintiffs, dated so and so. Next, revival letter dated so and so, executed by the defendants in favor of the plaintiffs. And then last one is, you say description of the property offered as security, give the full particulars along with the boundaries. And then the last one is, you mention what is called the total amount due. This is how the columns have to be filled up, and these columns have to be clearly mentioned and clearly described. If not, your suit for mortgage would fail. Then next one is, as usual, cause of action for the. Then the question is, the cause of action for the suit arose on so and so date, when the defendant number 1 approached the bank and obtained credit facilities and executed the cash credit agreement dated so and so in favor of the bank, and also on so and so date, when the defendants jointly and several at the defendants 5, 6, and 7 executed a guarantee agreement dated so and so in favor of the bank, and also on so and so date, when the defendants acknowledged and admitted their liability and executed COB, AOD, and revival letters, and also on so and so date, when the defendants were called upon to pay the suit amount which they have not paid till this date, and hence the suit. Next paragraph is, this honorable court has jurisdiction to try this suit as the suit property is located at Hyderabad within the jurisdiction of this court. Next para will be, the suit is valued for the purposes of court fee and jurisdiction at rupees so. So whatever is the exact amount due, you have to value the suit as per that, and then and a court fee of rupees dash is paid under section 19 or 20, schedule 1, article 1b and c, TGSV Act 1950, TGSV Act, so and so. Then next paragraph will be the suit is within time and within the period of limitation as the original documents were executed on so and so date, which was secured collaterally through deposit of title deeds on so and so date, and the legal notice also was addressed on so and so date, which was not replied to by the defendants, and hence the suit is within the period of limitation. Then the next one is the plaintiffs further declare that they have not filed any suit in respect of the same cause of action in any court, nor any suit is pending. Then the last para is the plaintiff therefore pray for a judgment and decree against the defendants jointly and severally as follows. 1. For payment of rupees so and so due towards the loan. Second one, in default of payment, a preliminary decree for enforcement of the mortgage by way of foreclosure or sale under Order 34, Civil Procedure Code, and C is for future interest at so and so from date of suit till date of realization, and D is for cost of the suit. Then the plaintiff signs under the seal and signature, and then the plaintiff also verifies the plain stating that the facts mentioned above. And last document is certified extract of the statement of account duly certified under the Bankers Books Evidence Act. And then the plaintiff signs, verifies, and the counsel also signs. And beneath it, you mention the list of documents 1, 2, 3, 4, 5, 6, whichever you are going to file with the date and with the particulars, and the party signs. And if it is regarding immovable property and more so because of market, you give the schedule of the property. What is the property that is offered as security that you mention it? All that piece and parcel so and so, in survey number so and so, is situated so and so, bounded on the east by so and so, west by so and so, north by so and so, south by so and so. And then after that, the party verifies and says that whatever particulars are given in the schedule is true and correct, and then he signs. And then the place where the plaintiff is filed, you put the place, and then you put the date and the docket. This is how a mortgage suit is drafted, sir. One thing I should remind you here, when I was discussing the topic on jurisdiction, please remember, in Telugu they say sthana balam. Sthana balam means wherever you stay, you have the power. Your party also has got the power. But please remember, in certain cases, I think if I'm correct, it's 17 or 18 of the question is Civil Procedure Code, which says that wherever the property is located, within whomsoever territory limits the property is located, the suit has to be filed at that place and not at the place where you stay. Residents will not give jurisdiction as far as filing a suit when immovable property is situated or located beyond the jurisdiction of the court. So this particular provision, you have to keep it in mind, and please remember, don't feel lazy. If you don't want to go there, don't go. Some other advocate will appear. But if you are the standing counsel for the bank, wherever the property is located, you will have to file the suit at that place alone, not at any other place. Suppose you don't mention the particulars of the mortgage or the documents which are deposited with you by way of collateral security, later on you cannot file a suit for enforcing the mortgage by proceeding against that property, because you have got what is called the provisions of Order 2, Rule 2, splitting of claims. Or let us say you have to ask everything at the same time. If you avoid doing anything, the question of constructive res judicata under section 11.4 also applies. All grounds of attack and defense which might or ought to have been taken, if not taken, will be deemed to be waived. So be very, very careful, sir. And then C is for this is how the plaintiff is prepared. Then and all the documents which you mentioned, the list of documents, they are all called suit documents. You have to file all the documents in original into the court, which is the foundation of your claim and which forms the basis of your claim. And later on, you cannot file it. And whenever you file a mortgage suit, the same thing process. Then you also file what is called extra copies of the plaint, extra copies of the material papers to every defendant who appears appears on the other side. And along with the plain, you are also supposed to file a verified affidavit under Order 6, Rule 15, bracket 4. What is verified affidavit, sir? Verified affidavit is the averments made in the plaint are true and correct and are made by us with full restraint and responsibility. And the plaint is drafted as per our instructions, and whatever is mentioned in the plaint is true and correct, and we vouchsafe to that fact. And then the manager or the party signs, and then it's sworn and signed or whatever it is, and it's attested by an advocate. So verification affidavit is absolutely necessary as far as a mortgage suit is concerned, or your money suit is also concerned. And along with that, you also file what is called an affidavit under Order 6, Rule 14 CPC. That means courts were not implementing it earlier, but now they are doing it. You mentioned you filed the affidavit. In the affidavit, you say name, address, and description of the plaintiffs, name, address, and description of the defendants. Then afterwards, down you say the addresses mentioned above of the parties are true and correct, and then the deponent signs it and files an affidavit. Then, if you are filing it as a power of attorney on behalf of the plaintiff, you are supposed to file what is called a petition for permission to prosecute the suit as the power of attorney under Rule 32 and 33 Civil Rules of Practice. There you say that I am the GPA holder of so and so, so and so. I have been authorized to represent the institution or represent the party as the GPA holder as per the GPA dated so and so, and the GPA is still subsisting and not revoked, and hence I request this court to grant permission to file and prosecute the suit for and on behalf of the plaintiff. And then the GPA holder signs, and the petition is filed under Rule 32 and 33 of the Civil Rules. 33 of the Civil Rules of Practice. Then one more thing you must remember is whenever you file a suit in respect of a charge over immovable property, you are also supposed to file a form called Form number 8. Form number 8 is a valuation of the property, serial number of the property, survey number, extent, market value of the property, rental value of the property, and the valuation which you give, under what provision you value the suit, and then the party signs it, and then it is also verified by the party, and along with these annexures, you file the suit. This is how a mortgage suit is filed. So we have finished money suits, we have finished mortgage suits. Now we come to partition suits. Third pleading is partition suits. What do you mean by a partition? Partition means where the party, excuse me please. Finish yes, yes, yes. What do you mean by partition? Partition is, suppose something, common understanding is, suppose, let us say, you host a party, and in the party, it's a birthday party, let us say. You order for a cake, and cake, a loaf comes, a brick. Then that, the birthday, happy birthday and all is over. Then the cake is not consumed at one. You're not like a bakasura trying to swallow the cake in one piece. Then you make it into small fragments, and each fragment is given to each of them who are the guests. So in the same way, a joint property, a property belonging to a particular family, is supposed to be like a birthday cake. And then, so long as they're united, so long as they're joined, it still remains a cake. But once they want to get divided and they want their respective shares, it is made into slices. And those slices are called the divided properties. And please remember, no one swallows a cake as a full. You make it into small pieces and then consume. In the same way, as far as the joint property is concerned, which belongs to a family, it is made into fragments and divided among the various people. That is called partition. And the process through which it is divided is called through partition, division, whatever you may call it. Here, how a partition suit is prepared is, all the other particulars I think you must know, is filed under Order 7, Rule 1, read with Section 26, name of the court, number of the suit, names and addresses to the parties, and then you say down, you say suit for partition and separate possession, and then you say the plaintiff above name or plaintiffs above name beg to state as follows. Then name, address, and description. Name, address, and description of the defendants. And third one is address for service, when you are the advocate appearing with your address and email and cell number. Next one is the address for service of the defendants is the same as given above in the cause title. Then we come to the brief facts of the case, that the plaintiffs and the defendants form part and parcel of a joint Hindu family, and they own and possess a property bearing number so and so, administering so and so, situated at so and so, in survey number so and so. Next para. Which was purchased by the Karta of the family, and the original document is filed herewith and marked as document number 1. Next para. That the parties are residing together with a joint mess and with the joint earnings, giving it to their father, and with the earnings of the sharers, the property was purchased by the Karta, and he is the manager and custodian of the property. Subsequently, differences and disputes have arisen between the parties, and they want to sever their joint status and divide the properties in the manner hereinafter mentioned. Next paragraph. That the plaintiffs requested the defendants to divide and partition the property on several occasions, but the defendants have not agreed to partition and divide the property. And hence, the plaintiffs, through their legal notice, called upon the defendants to divide the property by means and bounds. And the defendants, in spite of receiving the notice, have not responded to the notice, and hence is sued. Next para. You say that the genealogical tree of the family is given below. First, the ancestor from whom it has come, then the father, then from the father, how many sons he has got, what are the shares held by them, then 1/4 or 1/8 or whatever it is, you mention it. Then the relationship of the plaintiffs and the defendants also will be mentioned in the genealogical tree. Then, after that, cause of action for the suit arose on so and so date, when the plaintiffs called upon the defendants to divide the properties and give their separated share, and also on so and so date, when the plaintiffs, through their legal notice, called upon the defendants to divide the properties, but they have not done so, hence this suit. Then, next para is, this honorable court has got jurisdiction to try this suit as the parties reside and work for gain at Hyderabad within the jurisdiction of this court. Next para. The suit is valued for the purposes of court fee and jurisdiction at rupees so and so, which is and a fixed court fee of 200 rupees is paid under section 34(1) of the TGCSV Act, as the plaintiffs are in joint possession of the suit scheduled property along with the defendants. And the market value of the property is so and so. The 3/4 of the market value is so and so. The plaintiff's share is 1/4. 1/4 into the market value will be his share, and the suit will be valued on the plaintiff's share, whatever is the share. But please remember, if the plaintiff is out of possession, he has to pay court fee on 3/4 of the market value into his share, whatever 1/4. Suppose he's entitled for 1/4. 3/4 of 1/4 will be 3/16 of the market value will be the value of the suit. This, please remember, most of the advocates make a mistake by paying more than what is required. Suppose you are in possession of the property, no problem, you pay a fixed court fee. But if you are not in possession, you pay 3/4 of the share, what you have got. 3/4 of, suppose you say you have got 1/4 the share, that will be 3/16 into the market value. That will be the value for the suit. So to be better, to understand better, when you draft that court fee paragraph, you say market value of the property equal to so and so. 3/4 of the market value equal to so and so. 3/4 of 1/4, that is the plaintiff share, is equal to so and so. The valuation of the suit for the suit for the purpose of court fee equal to so and so. The total court fee paid so and so. Then the court fee is paid under challan number so and so, dated so and so, with State Bank of India, whichever branch it is. Then you say this honorable court has jurisdiction to try the suit as the parties reside and work for gain at Hyderabad, and the suit scheduled property is also located at Hyderabad within the jurisdiction of this court. Next para is, or you say, suppose there are different properties, and you say and one of the properties is located at Hyderabad, on whichever mandal it may be, within the jurisdiction of this court. And next one is the declaration that you have not filed any suit in respect of the same claim before any court, nor any suit is pending. Last one is prayer. The plaintiffs therefore pray for a judgment and decree for partition as follows: for partition and division and possession of their undivided so-and-so share in the suit scheduled property bearing number so-and-so. Second one is to appoint a commissioner to divide the properties by metes and bounds. And third one is for costs of the suit. Then the plaintiff sign, and then the counsel also signs, and it's also verified by the party, and the party also signs. And then the list of documents which you file along with the plaintiff, you mentioned it is a 1, 2, 3, 4, 5, 6, whatever it is, and the party signs. And if it is regarding an immobile property, the schedule also has to be given along with the boundaries, and the schedule has to be duly verified by the party who files the claim, and it is also signed by the party saying that the schedule mentioned above is true and correct. And then you prepare the docket also. Same procedure you have to follow. You have to file Order 6 Rule 50 verification affidavit, and also file Order 6 Rule 14 showing the addresses and also saying that the addresses are true and correct. And then after that, the question is, since it's regarding immobile property, you have also to file form number 8, and along with that you have to pay the bata, or what is called a process, under rule 61 of the civil rules of practice. And if you are asking for any interim relief, you must file form number 61 along with notice, show cause notice general, and for each party duplicate has to be given. As far as the suit summons are concerned, it should be given in triplicate, because you have to pay the court fee through court and registered post. Then all the material papers, each extra copy of the plain, extra copy of the petitions, extra copy of the material papers. As many defendants are there, so many number of copies have to be supplied. So this is as far as the partition suit is. And please remember, in a partition suit, the essential ingredient is two decrees are passed. One is a preliminary decree which says that the parties are entitled for partition and division and possession. And final decree will be passed when a petition is filed under Order 20, Rule 18 for passing a final decree, and a petition is also filed under Order 26, Rule 13 to appoint a commissioner to divide the properties by metes and bounds. And as far as allotment is concerned, only the court can do it. A commissioner cannot allot the various properties. Normally, it is done by lots by the court. But please remember one thing is, one of the tricks how an advocate retains a file with him is, suppose you have got complex case where properties are at Nalgonda, properties are at Karimnagar, properties are at Secunderabad, properties are at Hyderabad, properties are at Warangal, so on and so forth. But if one of the property is located within the jurisdiction of Secunderabad court, where you give the schedule of the properties, then they say you can file a suit in Secunderabad. You need not go to Nalgonda, you need not go to Karimnagar, you need not go to Warangal. That's how a clever advocate tries to retain his client with him and retain the brief with him. This is only the trick which I'm passing on to you, which I'm not supposed to tell you also. But please follow these guidelines. I think we have finished 3 pleadings. That is, one is called money suit ordinary, money suit mortgage suit. Third one is partition suit. Tomorrow I shall go to the other types of suits which are to be discussed. Thank you very much. Now the question hour starts.
చెప్పండి ఎస్ఆర్ గారు, రవి గారు.
Sir, namaste. I have a query regarding the NI Act, sir.
Yes.
Sir, is there a medical condition patient or physical handicap ki ఏమైనా is a court relaxation ఉంటుందా sir attending ki?
Attendant ki GPA ఇవ్వచ్చండి, but the question is the medical certificate has to be filed and the permission of the court is to be taken to give evidence, sir.
So, in which section, sir?
Permission for what? Permission, there is no section for that, sir. The section is you
NI
because the NI Act provision ఏం లేదండి.
Yes, sir. Yes, sir. Is it the physical handicap code is there required to permission?
Sir, then that in that case you can get that party examined in his residence.
Okay.
Order 26 కింద proceed కావచ్చు. Order 26 rule 1 and 2 la you can request the court appoint a commissioner to examine the person at his residence or shop, whichever it may be.
Okay. And as per CPC.
CPC. Not under NA Act. NA Act లో ఏం provision లేదండి.
Yes, sir. Okay, sir. Thank you, sir.
Welcome.
Thank you very much.
Yes, Mr. RRR.
అయిపోయింది.
అయిపోయింది.
ఎనీబడి ఎల్స్?
ఆ కేసులో 205 ఫైల్ చేయకూడదు సార్ సిఆర్పిసి.
ఓల్డ్ సిఆర్పిసి.
నాయకులు.
Yes.
ఆ సిఆర్పిసిలో 205 ఉంది కదా సార్?
ఇదే దాంట్లో కూడా ఉంది సార్, బట్ I don't know the corresponding comparative table, sir. Rule section 205 of CRPC says the prosecution is supposed to give all copies to you. If they don't give it, then you can file a petition before the court under 205 to direct the police to furnish copies. Are you able to follow, sir?
ఎనీబడి ఎల్స్?
Sir, good evening, sir.
Yes, Mr. Stuti Ketan.
Sir, banks take that is current bills next to photos of houses as collateral, sir.
Sir, be a bit loud, sir.
This consider as
Sir, kindly be a bit loud, sir.
Banks take current bills next to house photos as collateral, sir.
Right.
When they give loans, sir. So without there is boundaries, without that is survey numbers of that house, to such a manner they will give loans, sir. Then at the time of that is court proceedings, are these considered as evidence?
They are taken as evidence of possession, not evidence of title. Even your revenue records will only show your possession, but not your ownership, sir. There are various judgments to say revenue documents do not constitute documents of title.
Sir. So is it a?
It will only prove your possession of the property. Acts of possession.
So banks మీద రైట్ ఉంటుంది సార్, ప్రాపర్టీ మీద రైట్ ఉంటుంది. ఈ కరెంట్ బిల్లు తీసుకుంటాయి కదా, ఫోటోలు ఇవి తీసుకుంటారు.
అది తీసుకోవచ్చు సార్. Nowadays banks are only taking what is called Aadhaar card copy and your PAN card.
Okay.
Anybody else? Can we conclude the class today?
Sir, in case of partition suit, if the property is to be equally divided among the persons, then who will be the petitioner and who will be the defendant, sir?
Sir, all are plaintiffs and all are defendants in a suit for partition. No one is a plaintiff, no one is a defendant. All of them are interested in a common right that they must get their divided status. I'll put a situation also. Suppose the property cannot be divided, then under 2 and 3 of the Partition Act, it has to be sold by public auction, and the sharer should be given the opportunity of purchasing the property at the market price.
Okay. So there is no question of everybody is the plaintiff and defendant.
Exactly, sir.
So then the partition suit should be drafted accordingly, sir.
Yes, sir. But one thing, difficulty there will be the avariciousness of a person. The greed of a person is whenever the plaintiff says it's a joint property, he will say it's my self-acquired property. I have purchased it with my own money, so on and so forth. But that defense you will have to meet.
Okay.
But in all other cases, plaintiffs and defendants have a common interest. That is, the property has to be divided and the share has to be given.
Okay.
That's why 2 decrees are passed. And there is one more ruling also, sir, 1967 Supreme Court, which says if a preliminary decree is passed wrongly and some of the parties who are proper and necessary parties are not implemented, the preliminary decree can be set aside at any time, and then the shares will have to be reallocated.
Good evening, sir.
Yes, Galaxy.
Sir. Who is this? ఎవరు మాట్లాడుతున్నారు సార్? Who is this?
వసంతరావు సార్.
వసంతరావు గారు, please go ahead, sir.
Is there any provision to give any inner shares or just above? There is a custom to to give Jeshabhagam to the elder son?
Sir, that question is doctrine of survivorship has been abolished by the passing of the Succession Act, sir. Survivorship is no more available.
There is no Jeshabhagam at Livatam.
లేదు.
What about the family expenditure, sir? For income for the family benefit to do marriages or
దానికి a charge can be imposed on a property where the eldest son or someone can be made in charge and said, out of the income arising out of that property or sale of that property, the marriage of the sister or the marriage of the daughter should be performed. There will be a charge on that property, a responsibility cast on the eldest son to perform the marriages of his sisters.
Of course, sir, if the charge was cleared by the elder son, he can keep the property, sir.
No, sir. The question is, it remains in vogue till such time the daughters are married.
Daughters are married. The property was not
So, if the purpose is already accomplished, there is no question of charge remaining by implication. Sir.
Then can they, who is the charge of that property, can keep that property?
Provided he gets a share by a partition suit.
It was charged. It was discharged by the elder son.
Maybe even if it is discharged, it's an onerous obligation which is imposed, but still the property remains to be joined till such time it is divided. Please remember, we advocates will not allow things to happen like that. You say, "Nee vaata undi edu teeskora babu ante maname nerpistam."
Okay, sir.
Welcome.
సార్ పార్టీషన్ సూట్ లో 40 years బ్యాక్ మ్యారేజ్ అయింది
సార్.
ఎవరికి వాళ్ళ కూతురు
ఆకుల మల్లారెడ్డి గారు మీకన్నా ముందు ఇద్దరు ఉన్నారు సార్ అక్కడ. ప్రిఫరెన్స్ సడన్ గా వచ్చేసారు, డోంట్ మైండ్.
చామర్తి
సార్, చామర్తి శ్రీరామూర్తి గారు.
సార్, ప్రిలిమినరీ డిగ్రీ, ఫైనల్ డిగ్రీ అనేది రెండు ఉన్నాయి కదా సార్, అవి ఏ రూట్స్ లో ఉంటాయి అనేది కొంచెం చెప్పండి.
Sir, you know, when I discussed about CPC, I dealt with that, sir. Partition suits, accounts suit, then what is called partnership suits, partition suits, and then what is called mortgage suits, and then all other type of suits are where we have two degrees. One is called a preliminary degree and another is called a final degree. Preliminary degree is the court declares you to be entitled to a share, but how that share has to be divided, a final degree has to be passed, and then final degree will be passed only under Order 20, Rule 18 if an IA is filed, and along with that you file a petition under Order 26, Rule 13 to appoint a commissioner to divide the properties, and then after that the court by lots or by any other means allows the respective shares to the respective parties along with the possession.
Okay, thank you.
Mr. Venkat.
Sir, this is with respect to that final decree itself, sir. Earlier, the judgment decree was given on 2015, sir.
Yes.
Within limitation period itself, I want to file the final decree. So, as you said, under Order 20, Rule 18, if I want to file, before that, if I can get the wakalat of the party, instead of, even though the other advocate is not available, I can file, right, sir?
Yeah, in that case, if the other advocate is not available, you must file a petition that the advocate is not cooperating or the advocate is not found. I want to engage another advocate. Please kindly give me permission to engage another advocate who files the wakalat and to represent my case and file final degree petition, sir. You have to take the permission of the court.
Okay, under which section? It's a memo.
There is under the Advocates Act itself, sir, when a previous advocate is appearing, only 151, sir, there is no provision for that. But when another advocate was appearing previously, it is just out of courtesy you file that petition, sir. Because the question is, suppose his fees is not paid and the party comes to you, you have to see that the other side is not affected in any way.
So I will file a memo under the.
Not a memo, sir. You have to file a regular petition that we want to file a fresh wakalat as the advocate is not cooperating or is not found.
Thank you, sir.
Thank you. Mr. Mallareddy garu. Mallareddy garu, please go ahead with your question.
థ్యాంక్ యూ సార్. సార్, ఒక ఫ్యామిలీలో 40 years బ్యాక్ మ్యారేజ్ అయింది వాళ్ళ కూతురికి. సో వాళ్ళ ప్రాపర్టీస్ అన్ని కూడా డివైడ్ చేశారు. ఇప్పుడు తను కూడా నాకు షేర్ కావాలని చెప్పేసి వాళ్ళ బ్రదర్స్ తోటి సో ఇప్పుడు కోర్టులో కేసు ఫైల్ చేయమని చెప్పేసి రీచ్ అయ్యారు.
సార్
సో దానికి మనం ఆల్రెడీ అప్పుడు వాళ్ళు ఏమేమి ఆర్నమెంట్ ఇచ్చారు ఏంటి అనేది కూడా వాళ్ళు లిస్ట్ అవుట్, వాళ్ళ బ్రదర్స్ అయితే ఒక సైడ్ చెప్తారు, బట్ వాళ్ళ సిస్టర్ వచ్చేసి ఇంకోటి చెప్తారు. దీన్ని హౌ వీ కెన్ కన్సిడర్
under the amendment of Hindu Succession Act in 2005 and introduction of 29A, there they say a female here by birth she acquires a vested right, and when the Supreme Court was asked to interpret this provision whether it's retrospective or prospective, in 2020 Supreme Court, in the Vinita Sharma's case, they held that is both retrospective as well as prospective. The question of the rights in the immovable properties does not get vanished. The daughter can claim partition at any time as far as immovable property is concerned.
Thank you, sir.
Welcome.
Anybody else? Can we conclude the class for today?
Sir, hello, sir. Good evening.
Good
Who
evening.
is this? Who is
Sir,
this?
myself, Jamuna Tiwari.
That is Nokia.
Hi. Yes,
Please
sir.
go ahead,
Sir,
ma'am.
what is section 4 of Banker Book?
Banker's Books Evidence Act says the banker need not file the original ledger into court. A banker is entitled to file what is called a certified extract of the ledger, a true picture of the entries that are made in the ledger, and then get it certified by two officers of the bank under their signatures, and also certify that the extract mentioned in the extract filed herewith is true and correct, and the entries are still made available or still available in the ledger books. That is what is called section 4.
Sir, thank you, sir. One more, sir. How can we calculate the court fee basing on the market value
Sir.
for filing the court fee when we are filing the suit?
Madam, please give us a call. We can explain you what the phone.
Sir, sorry, I didn't get.
Please give us a call.
No, as far as court fees,
No,
as far as court fees are
Sir.
concerned, it is not a big secret, madam. You look into the Court Fees Act, you see the table which is given. According to that, you value the suit, and look into the Court Fees Act, look into the provision which is apt for your case, and then file it up. Mention that section, please.
All
Sir,
right.
I know in court fees are we have advocates diary the how we
That
can
is what I'm
calculate the
saying.
court
Give us a call, madam.
Don't follow the diary, follow the Court Fees Act.
That's what we give us a call to us, sir, madam. We'll explain you over the phone.
Follow the Court Fees Act.
Okay,
Okay.
sir. Okay, sir.
Okay.
Thank you, sir. Thank you.
Thank you. Venkat garu mali doubt unna. You have a doubt again?
Yes, sir. చిన్నదే సార్. అదే
Sir,
final
hold on,
degree
sir. Hold on, sir. Me doubt ఒకసారి clear చేస్తాం. Let's give a chance to other fellows, and then I'll come back to you. Please wait. Mr. Sridhar.
Yes, sir.
Mr. Sridhar. Unmute your mic, sir. Mr. Sridhar Guddam.
Sir,
Yes.
is it audible for you, sir?
Yes, sir. Please proceed.
Sir, actually, in my case, the plaintiff is
Ali
failed
sir, please
to
wait,
prove-
sir. Ali Khan sir, please wait, sir.
Yes, Mr. Sridhar.
Sir, plaintiff did not file any document whether the property is ancestor property which is acquired by the common ancestor.
Right.
But that common ancestor who was died 100 years back,
Right.
he could not file any document
Hmm.
to show that it is acquired by the common ancestor.
Right.
But in that one, in that ancestor, in Hindu undivided family, there are two branches.
Right.
Actually, I am for that first branch,
Right.
who is the karta in that family.
Right.
But other the descendants who are belongs to the second branch,
Right.
he filed the suit for partition.
Right.
But there is no document. It is acquired by the either common ancestor, great grandfather of the plaintiff,
Right.
or grandfather of the plaintiff.
Sure.
He is alleging that it is acquired by his father from his forefathers.
Yes.
He has taken that plea only.
Yeah.
So how can we succeed?
Sir.
But we have found the declaration of title, other cross shoot, declaration of title for that entire property.
Right.
But in that one, my plaintiff in the declaration shoot, my plaintiff, only she has revenue documents.
Right.
From 55 onwards, years onwards.
Kasra Pahani. Yeah.
No. So Kasrapani is not available, sir, in that area. Only just
Pahani Patrika.
Sessala Pahani only.
Yes.
In that one, in the cultivation column, it was mentioned as the self-cultivation.
The Swarjita. The self-cultivation. Right.
Self-cultivation only. It is cultivated by the Pattedar, who is the deceased father of the plaintiff in the declaration of the title.
Right.
So actually there is a maximum. The revenue records do not confer the title.
Yes.
But she had only one way, that she filed the declaration of title based on the revenue records only.
Sir, as far as declaration of title is concerned, sir, I refer to 34(1) of the Specific Relief Act, which says a mere suit for declaration without asking for possession is not maintainable. There are various judgments on that. Number one.
Yes, sir.
Number two, Justice Nagarjuna Reddy's judgment and Supreme Court judgment is revenue documents does not confer title.
Yeah.
It only proves possession.
Yeah. No, sir. In the declaration of title, we filed that declaration of title for the out of the 14 acres land. Declaration of title. Recovery portion also we sought the relief.
That's correct. That's the correct approach.
But we have only the base of the revenue records.
Revenue records, which has not been challenged for so many years, proves not only title. It's a possession follows title. Isn't it? That is as far as the law of jurisprudence is concerned.
Yeah, in the partition suit, sir, there is no evidence filed by the.
If there is no evidence, the suit will fail.
Based on the revenue records only.
No, revenue records is not conclusive, sir. I'm sorry.
But how you can prove that that property was acquired by the common ancestor who passed away 100 years back?
You have to file the Pahani of that 100 years back. Not possible.
Yeah. Thank you.
Thank you. And Ramakrishna garu. Binigi Ramakrishna garu. You were asking certain questions.
Sir, this is regarding advocate idanడి. ఒకవేళ అడ్వకేట్ అతను ఎన్ఓసి ఇవ్వలేదు అనుకోండి సార్, అది నా విషయం ఒకసారి జరిగింది. ఫీజెస్ అన్ని పే చేసేసాము.
Ramakrishna garu, I request you to come in English so that other states are not understanding.
Okay. So I am the person in that case as a relative.
Right.
I paid the fees completely.
Right.
But still that advocate has not given NOC.
If he has not given NOC, sir, there is a provision to say that you can file a petition before the court. The entire fees has been paid to the advocate. The advocate is not handing over the file. Advocate is not giving you the NOC, nor the documents which copies of the documents. And under the Supreme Court judgment, an advocate has no lien over the file. He has no lien over the documents. He has to hand it over to the party. In case he has to receive any extra fees, he must file a suit for recovery of that fees, sir. And then you can take the permission of the court to engage a new advocate, since your previous advocate is not cooperating with you.
What has happened is it was in the RR court.
Yes, sir.
Recently that bifurcation has happened. No, that case has been transferred to Malkajgiri court.
Yes, sir.
And all the way, this advocate was residing somewhere in Iyengar. He said that he can't go to Malkajgiri court,
yes,
and he said he forced us to approach particular advocate nearby Malkajgiri court.
You need not.
And he said that otherwise I won't give NOC.
If he doesn't give NOC, file a petition before the court. You state the same thing. He recommended a particular advocate whom you do not want to engage. You want to engage an advocate of your choice. He cannot dictate terms to you, sir. You can file a petition and take the permission of the court to engage another advocate.
Okay. That is been resolved, but we faced such a problem for around 6 months.
Is it before the PDJ Malkajgiri, sir?
Yes, sir.
Mr. Balabhaskar's court. Yeah.
Yes, sir.
Yeah.
That is an appeal suit, sir.
Yes, I know, sir.
Right. Mr. Venkat.
Okay. Thank
Mr.
you,
Venkat.
Sir, it is regarding the final decree, sir. If at all, if the if the shares are not properly reallocated, if the defendant want to set aside the ex parte decree and then
Sir,
need to file
1967, you just go through AR 1967 Supreme Court. I don't have the page with me. Say any number of pleading degrees can be passed and shares can be reallocated among the parties in such a way that it pleases everyone. There is no bar for it.
So if I want to file for reallocation, then under
you will have to file. You will have to file it in 151 only, sir. There is no other place.
I need to file an IA and
exactly, accompanied by an affidavit.
Thank you.
Thank you, Mr. Ali Khan Mir. Mr. Ali Khan Mir, please unmute yourself. Go ahead with your question, sir. You are texted on the chat box, but I requested to ask the same question on the open port. Vanita Balmi. Vanita. Miss Vanita. Are you there in the port, ma'am? Vanita. Are you there, madam? Vanita, madam?
Question 7.
Sir. Ali Khan sir asking, is there any limitation for filing a partition suit?
No limitation for filing a partition suit.
Limitation for filing a partition suit is 12 years. Cause of action mentioned in the Limitation Act.
That is 12 years, provided if you cross 12 years, you cannot ask, but within 12 years at any time you can file because it's for recovery of your share in the form of immovable property.
Ali Khan sir, sir, if the cause of action did not take place, father died 40 years ago, but the property was not partitioned till now. Can we file the partition suit now?
If the property is not partitioned after the death of a person at any time, it is maintainable.
Thank you. Vasantrao Garu, please go ahead with the question, sir.
Sir, another question, sir. There should be no suit for declaration without seeking any consequential relief.
Exactly.
But can we file recovery of possession without seeking the declaration of title?
You can do it. Recovery of possession will be you have to file it, but one thing is this: you will have to come under section 29 if I am correct. That is, the court fee has to be paid under section 29 of the Court Fees Act.
It is maintainable.
Yes.
Only seeking relief
of possession.
Thank you.
Thank you very much. Time to conclude the class for today. We'll see you again tomorrow. Thank you.
Thank you, sir.